Hello, I'm Greg Brown. I'm a partner at Cat & Roseman here in Chicago. I've specialized in employee benefits and executive compensation for 37 years, and that's included working with ESOPs, which is an acronym for Employee Stock Ownership Plans. I'd just like to take a minute to tell you a little story about one of my clients and how the ESOP was used in their family succession planning. The company, which is a technology company here in the Chicago area, first introduced the idea of an ESOP in the middle 80s, initially as a charitable giving technique, with the owner giving stock to the university that he went to and then having the university sell shares back to the employee stock ownership plan sponsored by the company, and the company funded the ESOP. This allowed the owner of the company to fulfill some charitable needs. And in a couple of cases, the ESOP was used for a sale to create liquidity so that he could make gifts to his children and grandchildren who were not involved in the business. Ultimately, the owner of the business reached his middle 60s, had some health issues, and was considering what to do with the company. The owner, like many owners, explored all alternatives, including third-party sales, and had a significant offer for the company, which he very, very seriously considered. However, at the end of the day, he felt that the loyalty of the employees who had helped him build the company from initially 75 employees to over 1,000 employees needed to be given an opportunity, which the employees readily embraced, put together a financing program, and they used the employee stock ownership plan to buy out all the remaining shares from the family. For the family, the yield was slightly less than what the third-party sale was going to be, although they were able to take advantage of the tax-deferred rollover under Section 1042 of the Code. What was most important, though, was preserving the family name on the business, the role in the community, the knowledge that all of the people that had helped the owner make his fortune were going to be held intact and weren't going to be at the mercy of some stranger third-party buyer, private equity fund, or otherwise, and that everything remained intact. In fact, the company has been a huge success. The owner remained on the board of directors for 5 years after the sale, and things have worked out very, very well in that instance. So when you're thinking about an ESOP, remember this little story, because it's not all dollars and cents and tax dollars. Sometimes it's more than that, although those are, of course, important. Well, you need to present the ESOP to him as an alternative, but he may not get as much money from an ESOP sale as he might from a strategic buyer. The reason for this is that the ESOP sale needs to have an appraisal, a written appraisal, stating that the ESOP is not paying in excess of fair market value. Fair market value is an art unto of itself, but many times a strategic buyer may be willing to pay more than what the appraiser might come up with as the fair market value. It may be 10% or 20% more, so he may not yield as much in terms of gross proceeds. However, you as an advisor need to think of the fact that that sale to the third-party strategic buyer will be a taxable sale, and the sale to an ESOP may be a tax-deferred sale. So you'll need to look at the after-tax yield and how it might coordinate with other succession planning and other family planning, and ultimately coming up with your answer. Well, I think you need to reach out and find experienced, qualified people who have done a series of employee stock ownership plan transactions, maybe in different roles. For example, the attorney you might want to see has not only representing selling shareholders and companies that sponsor ESOPs, but possibly fiduciaries of ESOPs, even entities that have provided financing for ESOPs, such as banks or insurance companies, and possibly even companies who have invested in employee stock ownership owned companies, such as private equity groups or venture capital companies. Finding experienced people is invaluable. You also need to see, you also need to go through the right process. And by that I mean you need to start out with a feasibility study, someone who's experienced in ESOPs who can come up with an analysis and tell you whether an ESOP is even feasible at all. You may also want to get together with an attorney who is experienced in doing ESOPs and have your basic legal questions answered, and also find out what questions have you not considered that you need to consider in advising your client. I think with the combination of answering those questions about tax effects, legal effects, how it might coordinate with estate planning, also understanding the feasibility analysis, that will tell you whether you need to go forward. Let's assume that you've done that and it's a go. Then I think you need to talk to the company's bank, because you're going to need financing. You may want to talk to a group of banks to see what their interest, but you should always talk to the bank that knows the company the best, to see whether financing will be available. The financing may not be available for the full extent of the sale that you contemplate, and so you may need to use seller financing. Again, that's where you're going to need experienced people, lawyers, trustees, and so forth. Now, you may ask the question, well, who's going to be the trustee of the entity? We normally suggest that we get an independent entity to act as trustee, even though it is perfectly legal for an individual, even including the seller or group of individuals, to act as trustee. That puts them in a conflict position that's possibly resolvable, but probably not worth the legal exposure that they may have from that. So we need to find an experienced ESOP trustee, which is not that difficult. I think you need to have a frank chat with the people that you were thinking about involving in the transaction, and let them know that you're going to remain involved, that's very important, that you're going to control the process, and that you have the confidence of your client, and even help to have the client indicate to them that you're going to be involved. The fact that you have the power to help your client choose the advisors normally will help control that problem. Well, yeah, and you know best what the client's goals and objectives are, what the client's characteristics are, and what some of the client's quirks are. And that client's going to be willing to tell you certain things that they're not going to be able to tell the other advisors because they don't know them well enough.
Probably also know the family.
Yes, and the family dynamics, particularly when you get into second and third generations, are key, and sometimes are in labyrinths.
What about using local professionals versus experts from outside of my community?
You may need a little bit of both, and by that I mean the experts are indispensable to the process and wading through what the various alternatives are and keeping you on course legally. But the experts are going to need the benefit of your local attorney, who's going to have knowledge of your articles, your bylaws, your minutes, and who really understands what the company's history has been and where all the issues are. That attorney will know, for example, whether you have any lingering environmental issues or income tax issues, labor and employment issues, or otherwise. That the experts, even with some due diligence, aren't necessarily going to pick up immediately or understand what the status of the various issues are. So the answer is you're going to need a combination of both. Well, your client may want to double track things, and by that I mean they may want to have Goldman Sachs go out and see what the interest is in your client and at what level. What will other companies be willing to pay for it and under what circumstances. We've seen instances where a company has done that and at the same time has looked at ESOP feasibility and even negotiated an ESOP transaction. And in one instance, they actually found better terms using the ESOP than they were doing that, because the third-party buyer, although it was willing to pay a little more upfront, that was also going to be a taxable transaction, but there also was going to be a significant escrow. The ESOP didn't feel the need for nearly as large an escrow, and the sale qualified for a tax-deferred rollover under Section 1042 of the Internal Revenue Code. And in another instance, we've seen a company do that, and we've seen the third-party buyer finally say, okay, we understand that the ESOP's real. Let's sit down. And the third party has come up with the funds that the buyer wanted, and the deal has gotten done. Now, I'm not suggesting that you need to do that in each and every instance, but it is a possible strategy, to protect your client and to protect your interest with the client. Your role is going to be very, very important, because that's the whole reason for the deal, is to provide your client liquidity and diversification. So you're going to need to work with that client to start thinking about what the strategy is going forward, after the sale. If you're going to be doing the tax-deferred rollover, you've got 12 months to decide exactly what the final investments are going to be. You're going to need to work very closely with an attorney or tax accountant to make sure that the various investments qualify as qualified replacement property for purposes of Code Section 1042, which generally is U.S. stocks and bonds, but there are a few little quirks that need to be observed in doing that. But your role is key, because that's the whole reason the client's doing the deal. The typical time frame from the initial meeting to actually getting the deal done, I'd say, is usually 6 to 9 months. I don't think you can do it in a shorter period, but the deals that get done the best are usually ones that are done with a very deliberate process and not rushed. This gives everyone a chance to do all the due diligence, to investigate the proposed transaction, get it designed and structured properly, allow the trustee and the financial advisor for the trustee to do their job, so that you have a transaction that's well documented, well thought out, and if anyone wants to challenge it later, either the IRS or the U.S. Department of Labor or a plaintiff group, that you have a defensible transaction. It also gives you a significant amount of time as the financial advisor to really work with your client as to what the long-term investments are. Does your client have a charitable bent? Will part of the proceeds be put into a charitable remainder trust or some other estate planning device? There's a lot of things that need to be considered, and they shouldn't be done on the back of an envelope.